Mark A. Pearson is the principal counsel at ARC Law Group, a law firm focused on advising creative, talented, and entrepreneurial clients in the areas of business, entertainment, sports, and technology law. Following his career as an award-winning television producer, Mark spent the past decade advising some of the hardest working acts in the music biz, including international touring artists Con Brio, Front Country, and DJ Mark Farino, as well as up and coming acts such as Barrio Manouche and Elise. In addition to his work in the music industry, Mark served as production counsel for Academy Award nominee Borrowed Time and was recently awarded the Governor's Citation Medallion for his service to the National Academy of Television Arts and Sciences, Emmy Award. Based in the San Francisco Bay Area, but with clients in Los Angeles, Chicago, New York, and Nashville, Mark also advises leading entertainment technology disruptors like TuneGo, Caffeine, and Fandor. You can reach Mark at Mark, M-A-R-K, at arclg.com or visit his website, www.arclg.com.
All right, thank you, and welcome to the Music Copyright, the 2x6 workshop, and we'll explain what 2x6 means in just a minute. My name is Mark Pearson, and I'm an attorney with ARC Law Group. I focus mostly on working with creative, talented, and entrepreneurial clients in the entertainment industry and some entertainment and technology crossover. My background was in television. I spent 10 years as a sports reporter and sports anchor, and then transitioned into law. I love what I do, and I'm very excited to be talking about music copyrights this morning, or this afternoon, or whenever you are listening to this particular broadcast. So let's get into it first by saying that if you don't take anything else away from this particular workshop, just remember a couple of key concepts. First, there are two music copyrights in every piece of recorded music. Very important to recognize that, and this is where a lot of clients get confused, especially people that are creative and working as musicians or working in some other creative endeavor within the music industry. That the concept of there being two music copyrights can get very confusing and can make drafting legal contracts somewhat difficult, and especially if you're trying to explain these concepts to someone, sometimes it can get a little bit difficult. But nonetheless, if you kind of understand just the basics, and I try to counsel clients on the basics, it will make their life a lot easier in understanding that there's this fundamental concept of two music copyrights for all pieces of recorded music. The first one is the copyright in the actual musical composition. So every piece of music is going to have a melody. Most music, popular music has lyrics as well. But the music composition copyright is the copyright in the lyrics and melody of the song. So it's not the rhythm, it's not the beat, it's not the arrangement, it's the lyrics and melody of the song. This copyright is usually associated with music publishing or with the songwriters of the song or the songwriter's publishing company. So anytime we talk about publishing or publishers or songwriters, we're talking about the composition the composition copyright, or the copyright in the musical composition. Illustrated, for example, here in the sheet music. So sheet music is what we associate with the musical composition. You don't actually have to write sheet music in order to create a musical composition, just by virtue of creating music that's new and original and creating a new melody, or writing new lyrics, or just singing new lyrics that are then recorded. You have created a musical composition. So don't be confused into believing that you actually have to be able to write music and understand how to do that in order to create compositions. No, all you need to do is actually create the composition and fix it into some tangible form, including recording it. Okay, so that's your first copyright of the two, the copyright in the musical composition. The second copyright that we're going to be talking about is the copyright in the master sound recording, or the sound recording that embodies that musical composition. So you have to have a musical composition first, and then you can create one or more master sound recordings from that musical composition. Think about a song like maybe the Rolling Stones' Satisfaction, written by Jagger and Richards. That song has been recorded by lots and lots of different bands. The composition copyright is always controlled by Jagger, Richards, and their respective publishing companies. The different sound recordings of Satisfaction are all going to be owned and controlled by the artist or the artist record label or distributor that creates those sound recordings. So Devo did a really cool sound recording of Satisfaction that is owned by Devo's record label. Britney Spears did a really interesting recording of Satisfaction that is owned by her record label. But every time those songs are used, it is the same underlying musical composition from Jagger Richards that also has rights. So anytime you hear a piece of recorded music, no matter where you hear it, it is going to be subject to two separate and distinct musical copyrights. And those copyrights, of course, are in the musical composition or the publishing copyright and the master sound recording copyright, illustrated here by an album on vinyl and a cool record player too. Okay, so two music copyrights. So the next thing, if you don't take anything else away from this particular workshop, is to recognize the concept that there are 6 separate revenue streams for every recorded work. 3 revenue streams that stream from the composition copyright, and 3 revenue streams that stream from the sound recording copyright. So 2 by 6, 2 copyrights, 6 revenue streams in total for the use of those 2 copyrights. So what are the revenue streams? The first is the mechanical right, or the mechanical royalty. This is the royalty or the right that flows from the actual physical use of the sound recording and the physical use of the embodied musical composition in that sound recording. And there's a royalty payable to the owner of the composition and the owner of the sound recording every time a physical copy of a work is used or sold. A physical copy of the work, as illustrated below, includes interactive streaming. And this is a big issue, of course, today because a lot of music is sold or used through streaming. So interactive streaming, Spotify, Amazon, Apple, where you get to choose the music that you're listening to, is considered a mechanical right and subject to a mechanical royalty, meaning the law says, yeah, that's the same as actually owning a physical copy of the song because you can choose when to hear it whenever you want. So treated the same as if you went to Amoeba Music and bought a copy of the album on vinyl or CD. The law treats the distribution through interactive streaming the exact same way, subject to a mechanical royalty. Mechanical, think about that as being tantamount or related to the actual creation of some type of product from the music in a physical form. So that's your first revenue stream. And of course, there are 2 royalties that flow from that, one to the composition and one to the sound recording copyright owners. Okay, the second revenue stream is a performance royalty. This is a royalty that is received from the public performance of a song in a recorded format. So there is obviously a public performance royalty when a song is played live, in which case only the composition copyright owner would be subject to providing some sort of license or receiving a royalty when a song is played live because the master sound recording is not involved in live performance of a song. But the master sound recording is involved in the live performance of a song when it's played on the radio, or when it's played at a sports venue, or when it's played on television. So there, or on a jukebox when you're at a venue, or over a PA system when you're in a restaurant or shopping at the mall. There is going to be a performance royalty that is going to be subject to potentially the composition and the sound recording for those types of public performance. So no sound recording usage when you play a song live as a band on stage, but definitely sound recording usage when a song goes out on the radio, television, streaming on the internet, or all other places where songs are publicly performed. And so, therefore, when a song is played on Pandora, there needs to be two royalties paid and two sets of rights thought about, and so that's why we have that here. Pandora, obviously being non-interactive streaming, treated much like a radio station where you just turn it on and you kind of pick your station and listen to the songs. Same thing with terrestrial radio. Again, performance royalty would flow through to terrestrial radio based on the fact that it is a public performance of the particular song. Again, we're going to talk about some limitations that go along with the sound recording and public performance, but we'll get into that in a few minutes. But for right now, just recognize the concept that anytime a song is performed publicly, other than just a live performance by a band on stage of the song, there's going to be two sets of rights and two royalty streams that come from that, and that is your second royalty stream, again, one for the composition and one for the sound recording. And then third is your synchronization rights or your synchronization licensing. This is the right to incorporate the music into some audiovisual work, a movie, a TV show, a video game, any type of audiovisual work. There will need to be a license and money paid both to the owner of the composition and the owner of the sound recording in order to put that one recorded song into a movie or a TV show. So very important to recognize, again, your synchronization rights, and that is the third of the three revenue streams, again, one for the composition and one for the sound recording. So again, in looking at this, there is a mechanical royalty and right, a performance royalty and right, and a synchronization fee and license that is going to generate revenue for the composition and for the sound recording. So therefore, 6 different revenue streams, 3 each for the composition and sound recording, 2 copyrights, 1 in the composition, 1 in the sound recording, and therefore we have, if you don't take anything else away from this workshop, just remember there are 2 music copyrights and there are 6 revenue streams that flow from those 2 music copyrights. Okay, let's take a step back now and focus a little bit on general copyright law and what copyright law is and how all of this interplays in the actual copyright law itself. So copyright law is 17 USC 101. It's federal law, and it essentially is there to protect the tangible expression of an idea. So copyright law does not protect an idea itself. It only protects the idea once that idea is set forth into a tangible form. Another key concept to think about with copyright law, and we won't dive too much into this, but something just to keep in mind, is that copyright law only protects form. It doesn't protect function. So there's lots of different things that are creative or created by people who use lots of skill and talent, but they're considered functional and so therefore are not subject to copyright protection. Things like designs for clothing or furniture designs or the layout of a keyboard, things like that, that we would consider functional, that provide some level of overall function that trumps, so to speak, the ability for the creative elements to obtain copyright protection. So copyright protection really applies to things that are under the guise of form. And so that's why the copyright law actually lays out the particular categories that are going to kind of be overarching in fitting into this concept of form. And so in the Copyright Act, it actually calls out musical works and sound recordings, which are illustrated on the slide, along with lots of other categories of works, dramatic works, which is obviously like plays and screenplays and things like that, pantomime, choreography, pictorial and graphic works, your fine arts, literary works, novels and whatnot, audiovisual works, movies, compilations. So if you put something together in a particular way, like information, so the information itself, facts, might not be subject to copyright protection, but the way that you arrange those facts into a book would be subject to copyright protection. Architectural works, obviously, as well. But the Copyright Act actually calls out musical works, which is the composition copyright, and sound recordings, which is the master sound recording copyright, specifically, which is interesting to note. Okay, so what do you have if you have a copyright? What does that mean? So copyright gives the owner of the copyright the exclusive right. Very important concept. Nobody else can say, well, I get some of this because, no. If you created it, either alone or with others, the group or you individually have the exclusive right to reproduce, distribute, perform, display, and create derivative works. Um, that is what copyright grants to you. You don't need to do anything special. You don't need to register your work. You don't need to do anything other than create the work in order to assert your copyright rights. We'll talk in a second why registration is important, but your copyright rights are fully vested the moment you create something, and you have these 5 exclusive rights. The first 4 are pretty straightforward. Reproduction, that's your right to be able to make copies of things. Distribute, you have the absolute right to decide when and where and who gets copies of whatever you're working on or gets the original of what you created. The right to perform, the right to display, those are pretty straightforward and self-explanatory, but the derivative works is where sometimes in copyright we have the gray area and where there are interesting case laws and disputes over this idea of a derivative work. So since we're talking about music, the classic example in modern music for the last 30 years or so is the idea of a sample, where you sample a previous sound recording and composition into a new work. The law decided and determined through lots of different court cases that a sample was a pure derivative work, and therefore the right to the sample and the right to the work that the sample is incorporated into is subject to ownership of the original author of that sample. And again, since we're talking about 2 music copyrights, if you sample a work, the owner of the composition and the owner of the sound recording both have rights in the respective sound recording and composition of the work that you are creating because the law considers it a derivative work. This made a lot of sense in the late 1980s when we looked at what samples really were. And you looked at albums like from the Beastie Boys, Paul's Boutique, or you looked at 3 Feet High and Rising from De La Soul, Takes a Nation of Millions to Hold Us Back from Public Enemy. You look at these albums, and when you listen to the samples, you hear the James Brown, you hear the Meters, you hear Led Zeppelin. You hear the bands and you go, oh, that's Led Zeppelin being, and we didn't know the word sample then, but you recognized those musical elements that were being sampled into those albums. So it made sense that the law came back and the decision was made that those were derivative. However, now when things are sampled quite often, it's like 1 or 2 bars that are then heavily manipulated electronically. And unless you know to look for it because somebody told you, hey, I think that might be your sample, and you decompile it, you might not ever be able to recognize that your work was sampled into something that is being created new today. And so the idea and the concept of sampling may be open to revisiting to make that determination of whether or not it's still a derivative work. If it's not a derivative work, if we're saying that the sample is so manipulated that the original rights holder of the copyrights in that sample should not have rights, then we call it a transformative work. A transformative work would then not be subject to any copyright protection for the original author. And there's lots of things in copyright that demonstrate something having become transformative. But for music, the real key is this concept of sampling. And right now, there is no transformativeness when it comes to sampling. It is a pure derivative right, belongs to the original copyright holder. So just a little side note on sampling and how that works within the 5 copyright rights that you have when you create a work. Okay, sticking with the theme of general copyright overview, copyright duration. There was a change in the Copyright Act in 1978. So works that are pre-1978, there's some technical rules, which I'm not going to get into here, but generally any work that was created after 1978, the copyright is good for the life of the author plus 50 years. That plus 50 years was changed in the early 90s. The Sonny Bono copyright term extension extended it to the life of the author plus 70 years. So any works that are created now are good for the life of the author plus 70 years after the author's death. except in the case of a work for hire. So, briefly, a work for hire is a scenario that's created when someone other than the author is going to be considered the owner of the work from the moment the work was created. Work for hire can only be created by a written agreement. It is usually in the context of an employment scenario. If you can imagine in the recording industry, a record label hires a band. The band signs a recording agreement. Part of the recording agreement is a work for hire that says that the record label owns the master sound recordings created by the band, and therefore those master sound recordings are never considered to have been authored by the band. They're considered to be authored by the record label, thus a work for hire. You also see this in employment scenarios in like software or any type of creative industry where you're an employee of a company. You're going to sign a document that says everything I create while I'm working for this company that is within the scope of my employment belongs to the company. So since in a work for hire scenario, there's no physical being that the authorship is tied to. It's usually tied to a company or to a business or to a person that's operating as a business. We can't use this life of the author plus 70 years. So in those instances, we say that the copyright is good for 120 years after the work is created or 95 years after publication, whichever is shorter. Publication meaning the first time that it's made available to the public. Um, so that's a work for hire. Again, work for hire can only be created within a written document, and it is limited in to only certain works. So not every type of copyright work is subject to work for hire. But in the music industry, it's important to note work for hire because just about every recording contract is a work for hire where the band or the artist is giving up the rights to the thing that they create, the music, the sound recording, okay, that one copyright that they create to the record label at the moment the work is created, and the record label therefore stands as the author of the work. Okay, so stepping back to this copyright extension, Sonny Bono obviously had worked in the entertainment industry for many years and was a member of Congress representing Palm Springs in the early '90s, and he was lobbied very heavily by a number of different entertainment companies, but one in particular who had a vested interest in seeing the copyright being tied to the life of an author extended from 50 to 70 years. I'm sure if you think about it, it's quite obvious what company would have a vested interest in doing so. But for sake of argument, obviously, we're talking about Disney and Walt Disney, right? Because what happens when a copyright? Oh, there's no music here. Beautiful. That's right. So what happens is when the copyright duration comes to an end, that means the work goes into the public domain, meaning anybody can use the work without having to get permission or pay any money for that use. Meaning that at some point, the original Mickey Mouse cartoons, the Steamboat Willies, will become public domain, and anybody will be able to put that on their TV channel and not have to pay any money for it, or make copies of it and distribute those copies without having to pay any money to do that. Um, there are some nuances to this that happen in trademark law and some other areas of law that might make that process difficult for companies to be able to use the Disney works that are going to go into the public domain. But nonetheless, eventually they will go into the public domain, and this is probably why you've seen over the past decade or so Disney have this shift across the board into acquiring other properties that they will be able to continue to control the exclusive rights on for many, many years, such as Pixar and Marvel and the Lucasfilm catalog, Star Wars and Indiana Jones, because they're going to be able to control those rights for quite a long time, whereas Mickey Mouse and Donald Duck and some of the original Disney cartoons are going to end up public domain. Lots of things are in the public domain. Like Sherlock Holmes is a good example. Anybody can write about Sherlock Holmes or do a movie, and they don't have to pay Arthur Conan Doyle's estate any money because those works are in the public domain. Um, okay, so that's a little bit about the duration. Copyright registration. Again, as I mentioned, you do not need to register your copyright in order to secure copyright rights. All you need to do is create something and fix it into a tangible form, and you have the copyright rights. If you do it with somebody else, the two of you together jointly own the copyright rights. or three people. The three of you jointly will all own the copyright rights. But nonetheless, copyright rights vest the minute something is created into a tangible form, provided that it's actually subject to copyright protection. Again, we talked about things like functional items would not be subject to copyright protection. But registration is important, and registration, especially in music, is something you want to do because there are some advantages in the event that somebody infringes on your copyright rights. So what does registration, which is done with the Library of Congress, which controls the Copyright Office, what does that provide the copyright owner? One, it provides prima facie evidence of your rights in the work. You actually have a document that states the date the work was created and who the authors are and who the claimants on the rights are. And that information is public record and would serve as a shield prior to anyone being able to challenge your copyright. They'd have to defeat the evidence that was presented of your copyright registration. Okay, second is your ability to enforce your rights in federal court. Obviously, there's jurisdictional issues that might give you the right to sue in federal court regardless, but if you have a registered copyright, you can always choose to sue in federal court, which obviously can provide many, many advantages that we're not going to necessarily get into here, but federal court is definitely advantageous in the event of a dispute over copyright. The big reasons, though, for copyright registration, other than the prima facie evidence, is actually pretty important, but statutory damages. So as we looked in your copyright rights and the four rights that you have, not including derivatives because that can be a gray area, but on the simple ones, if I copy your material, if I take a photograph that you took and that you own the copyright in, and I put it on my website to advertise my goods and services, it's going to be pretty easy for you to prove that I did that and infringed your rights. You go to court, you say, I took that picture. I didn't give a license for Mark to use that picture on the website that he's operating, and therefore he's infringed my rights. That's pretty much the case. And unless I can produce some evidence that the plaintiff didn't use the picture, or I can produce some evidence of a license that I had directly with the plaintiff, I lose the case. But then we get to the damages phase. And what are the damages that I caused by putting the picture on my website without permission? That can be difficult to prove. It can also be costly and take a lot of time to prove what the damages are. You might have to call expert witnesses in. You might have to provide evidence showing that you're a commercial photographer and this is what you would normally charge a client. All kinds of things can go into it, and it might not be a lot of money, or it might be a substantial amount of money, but tough to prove that. If you have a registered copyright, and there's some nuance to this, but in general, if you have a registered copyright, you do not have to prove damages. Built into the Copyright Act are statutory damages. So prove your case that I used the material on my website without your permission, and then say to the judge, statutory damages, and the judge will make a determination of somewhere between $20,000 and $150,000 per infringement of an award against me for my use of your copyright rights without permission. So if I use let's say I use 10 of your pictures on my website without permission, I would be facing a potential of a $1.5 million judgment against me for that use. So what this has done is created a situation where just about every copyright claim where it's fairly cut and dry that someone made a mistake or someone did something unscrupulous ends up settling, because the statutory damages provision makes it very easy for the plaintiff to be able to simply prove their case and then let the judge decide based on how willful the judge believes the infringement is to make an award of damages without having to take into consideration any evidence or testimony as to what the actual damages are. Super, super advantageous for the plaintiff. And this only comes about, and you only have the ability to take advantage of statutory damages if you have a registered copyright. You also get your attorney's fees paid if you prevail, but like I said, most of the cases end up settling, so you don't have to necessarily worry about the attorney's fees, but they're probably going to be part of the settlement. But nonetheless, the statutory damages provision is very, very important. Registration is fairly simple. You can do that online at the copyright.gov website. And even when, when we do it at ARC Law Group, we usually charge our clients like $150, including the filing fee to do a copyright registration, because it is a fairly straightforward process. Unlike, filing a trademark or a patent, which has some nuance and detail to it, a copyright is very straightforward and there's no examination process. Except they take a quick look at it to make sure that it actually qualifies as a copyright and is not something that doesn't qualify as a copyright. But other than that, it's a fairly straightforward process, and has a low filing fee of $55 or $35, depending on the type of work. So it is not a difficult thing to do, and encourage anyone who's working with creatives, or if you're a creative yourself, to register the copyright in your work. So if somebody does infringe, statutory damages will be available to you. Okay, now we know a little bit about copyright. Let's circle back to this concept of 2x6, 2 music copyrights in every recorded song, and 6 royalty streams. So let's start with a song, and we're going to start with the song Hurt by Johnny Cash. So let's take a little listen to that song in case you're not familiar.
I hurt myself today to see if I still feel.
Okay, so Hurt was recorded by Johnny Cash shortly before he passed away. It appears on the album American 4, The Man Comes Round. That album is owned, the master sound recording of Hurt appearing on that album is owned by the record label American Recordings, which is a subsidiary of Universal. The song was not written by Johnny Cash. It was written by Trent Reznor, who some of you may know from Nine Inch Nails. He also does a lot of music scores now. I think he works with Steven Soderbergh a lot. But Trent Reznor from Nine Inch Nails wrote that song "Hurt." It had appeared on a Nine Inch Nails album back in the 90s. But Johnny Cash liked the song, and his version is very cool. If you ever go to the Johnny Cash Museum in Nashville, they have a large exhibit on this particular song, and it is a cool song. And you hear it 1,000 times as you're going through, and you still like it when you come out. At least I do. But Johnny Cash didn't write Hurt. Trent Reznor did. So we've got a sound recording that is owned by the record label, performed by Johnny Cash, and we've got a composition that was written by Trent Reznor. Okay, so those are your 2 copyrights, okay, in the sound recording. That was, hold on, we got the song again. We don't need to listen to the song again. Okay, again, so you've got the 2 music copyrights that are in this one recorded song. The musical composition, lyrics and melody, written by Trent Reznor. He has a publishing company that administrates his rights. His publishing company is called Leaving Hope Music. And so Leaving Hope Music controls the rights to Trent Reznor's composition in the song Hurt. But Trent Reznor is still the copyright owner of that song. He just has a contractual relationship with Leaving Hope Music to administer the rights to that song. The master sound recording is actually owned by American Recordings Universal. Johnny Cash does not own the sound recording. He is an economic beneficiary of the rights to the sound recording by contract, by his record agreement with American Recordings, but Johnny Cash does not own the sound recording. Johnny Cash does not own either of the copyrights in this scenario, which is why my favorite picture of Johnny Cash and him giving us the middle finger is apropos, because the song is associated with Johnny Cash, yet he actually has no copyright rights in either of the 2 copyrights for Hurt. Trent Reznor owns the copyright licensed out through Leaving Hope Music in the musical composition, and American Recordings, subsidiary of Universal, by virtue of its recording contract with Johnny Cash and the work for hire provision in that recording contract, owns the master sound recording copyright for Hurt. So Johnny gets to give us the bird on that one. Okay. So where does this really come from? I mean, this is actually, as we've talked about at the top of this workshop, it is actually written into the Copyright Act. So Section 102 of the Copyright Act actually says, here it is, musical works, including the accompanying words. So musical works is the lyrics and the melody, is the subject matter of copyright, and sound recording. So there it is right there in the law, the text as written, Section 102 of the Copyright Act. specifically protects musical works and sound recordings. Musical work in this scenario is the composition Hurt, written by Trent Reznor and licensed out through Leaving Hope. The sound recording is the physical master sound recording appearing on the album, Johnny Cash's album, and owned by the record label, and that is the sound recording copyright in our scenario. So, thinking about we'll talk about sync licensing and how that interplays in a second. But thinking about the mechanical rights that we talked about at the top of the workshop and the performance rights, that too is exemplified in the Copyright Act, Section 106, where we talk about the right to reproduce and distribute. Those are your mechanical rights, your rights to actually fix the composition and the sound recording into a physical form and distribute the copies of those physical form of those two copyrights. So a CD or a digital download or an interactive stream. That is reproduction and distribution rights or mechanical rights in the two separate copyrights. The performance rights, again, right there, Section 106, subsection 4, the right to perform. And then in the case of sound recordings, the right to digitally transmit. So we're going to talk about this in more detail, but basically the gist is that anytime you use a piece of recorded music and it's performed, okay, so performed to the public over a radio station, TV, streamed, or played live, jukebox, there's going to be a royalty or a right or a license that needs to be secured from the songwriter, the publisher. So in this case, Hurt from as written by Trent Reznor, Leaving Hope Music administering his rights. Leaving Hope would need to issue a license and receive money for the public performance of that song. But the record label only gets a public performance right and only has the right to collect a royalty on public performances of digital audio transmissions. Meaning, if the song is played on terrestrial radio or over the regular TV, over the air broadcast television, the TV station or the radio station does not need to secure a right or pay any license to use the sound recording. And we'll talk more about that in a minute, but that is a key concept in U.S. music copyright law, that there is no performance right for sound recordings on terrestrial or over-the-air broadcast television or terrestrial radio. Okay, so we've got these rights in the song, the mechanical rights, and again, that's the rights to make copies. You need those mechanical rights in the sound recording, and you also need the mechanical rights in the composition every time you're going to make a physical copy of the song and distribute it to the public. Performance rights, again, this is the right to play the song publicly, and you're going to need a right to do that and pay a royalty in every instance to the owner of the composition, and in certain instances for digital transmissions to the owner of the sound recording. Okay, so how does this work in our scenario with the song written by Trent Reznor and then recorded by Johnny Cash for Universal through American Recordings? Okay, so we need to get a mechanical right. So American is going to own the mechanical right to distribute because they have the contract with Johnny Cash that says that they are the copyright owners of the sound recording. So American is the distributor of the music. They're the ones that are going to put it out into the public through their distribution channels, but they own the copyright to the master sound recording, so they don't have to worry about that. But they do have to get a mechanical right to utilize the composition. So they must secure a license from Leaving Hope Music called a mechanical license in order to distribute the mechanical rights to the composition. Now, if Johnny Cash had written the song, he would probably have a section in his recording agreement called a controlled composition clause that covered this and gave the record label the right to the mechanical use of compositions written by Johnny Cash as part of the recording agreement. But here, since it's a cover song, American Universal needs to go to Leaving Hope Music and secure a license. As part of the United States copyright law, there is a provision called the compulsory mechanical license, meaning if you would like to do a cover version of a song and it's a straight ahead cover, you're not changing the lyrics or the melody, you can adapt and arrange it to fit your musical style, but you're doing a straight ahead cover, you do not need to get permission from the copyright owner. You just need to secure a license and pay money every time you sell a copy of the song. Very key concept, very important concept. So in this particular instance, American did not need to get permission from Leaving Hope Music. They just needed to secure a license. The license that they get is secured through a company called Harry Fox, or HFA, which anybody can go to that wants to do a cover song and say, Harry Fox, I'm going to do a cover song on an album. You fill out a form, and then you're going to pay a statutory mechanical royalty, currently 9.5 cents. So, in this particular scenario, American, they have an artist, Johnny Cash, signed to their record label. They're going to have that artist do a cover version of a song. They will own the sound recording to that cover version because of the recording contract with Johnny Cash. And they will need to get a compulsory mechanical license through Harry Fox for the benefit of Leaving Hope Music and Trent Reznor that will pay them 9.5 cents every time a physical copy of the song is sold. If it comes to streaming, Harry Fox currently administrates as streaming mechanical royalties as well. We're going to talk about how that works in a minute, but conceptually, you would also need you also can secure and pay a compulsory mechanical license on streaming. It's just not 9.5 cents. It's a different royalty rate that's set, and we'll talk about that and how there's going to be some changes to how that's done in a few minutes. Okay, so that's your mechanical right. Now you can put the album out. Your American Records, you own the sound recording, so you have the right to distribute that. Now you've secured this compulsory mechanical license, and so now you have the right to distribute the song. You have both copyrights to distribute the song. You can sell CDs with Hurt on the CD, and you're going to pay Leaving Hope Music through Harry Fox 9.5 cents every time that copy's sold, and you're going to collect the rest of the money from whatever price you pay and whatever agreements you have with distributors or manufacturers or whatnot. Okay, so that's that. But the song also needs to be performed, right? The song's going to go on the radio, or it's going to appear in a TV show, or it's going to be out there and be performed. It might end up on a jukebox in a public place. So there's also going to be a performance license attached to the song. The performance license, obviously, if American owns the sound recording, they don't need to worry about a performance license for the sound recording, but they are going to get paid if the song is performed. But there does need to be a license to the public performance of the song and money paid if you are the songwriter in every instance. As we talked about earlier, sound recordings don't always get a performance royalty, but composition copyrights do. Performance royalties payable on the composition copyright are administered through what's called a performing rights organization. ASCAP, BMI, CSAC are the three most popular or well known. What they do is they go to all of the different places where songs are performed, radio stations, TV stations, jukebox companies, companies that license out music for to play in your shop at the mall, public venues where music is performed. Like if you go to a baseball game, the venue, the stadium's going to have a license that they secure from ASCAP, CSAC, BMI, and others to be able to publicly perform the song. And what happens is the PROs will go to, say, your favorite radio station, and they will issue a blanket license to that radio station to secure the public performance rights to all of the BMI or ASCAP or CSAC catalog artists. And the radio station will pay that blanket license, and then they will report to the PROs what songs they played on their station. Generally speaking, the PRO will then take the amount of money that they collected on the license, divide it by the songs that were played, and then pay out the songwriters. It's a little more technical than that, but that is the general gist. So the PRO handles all of the administration and the licensing for the money for the public performance of the composition. And they set the rates. So essentially, when it comes to mechanical licensing for the composition, the rate set by statute, 9.5 cents for physical copies, and then a digital streaming royalty rate that is a bunch of zeros and then finally numbers that is set by statute. That's what you have to pay if you create a copy and sell it, or create a copy and stream the composition rights. For the performance royalty, the licensing is all handled by the PRO. So if you're a songwriter, you don't have a lot of control over what you're going to make on these first two royalty streams, the mechanical and the performance, because they're set by statute or negotiated and set by your PRO that you sign up with. And you can choose if you want to be ASCAP, CSAC, BMI. You're not tied to any particular one. You have the choice to kind of figure out which one's going to work best for you, but they all essentially work the same way. They set the rates. You don't negotiate that portion of it. Digital performance, again, if the song is now played digitally. So your favorite radio station, you listen to it in the car on the radio, they're not paying any performance royalty for the use of the sound recording. They are only paying a performance royalty through the PRO for the use of the composition copyright, and they're paying that based on the blanket license that they get from the PRO. But if your favorite radio station also streams online through iHeartRadio or through their own website, now they have to pay a performance royalty to both the composition copyright holder and the sound recording copyright holder. As we saw earlier when we looked at the actual Section 106 of the Copyright Act, we saw that certain digital transmissions of the sound recording were subject to a royalty. This was a change that was made in '98 when the Digital Millennium Copyright Act was enacted, another change to the Copyright Act. Prior to that, there was no performance royalty paid anytime for the use of a sound recording. But when they redid the law, the lobbyists for and everyone that was the kind of the dynamic shifted towards the industry players and away from radio and television, and so they were able to negotiate a digital royalty for the use of the sound recording on a performance. So now, if you have a digital radio station, you pay two blanket licensing fees. One is going to go to the owner of the composition copyright in the same way as it goes to them if it's played on your terrestrial station through the PRO, ASCAP, CSAC, BMI. The second royalty is going to get paid to the owner of the sound recording, and that's going to go through an organization called Sound Exchange. So owners of sound recordings sign up with Sound Exchange, and they receive a royalty that's set again by statute. They don't get to negotiate it. That is paid by digital entities that are streaming music, and then they pay money, and Sound Exchange collects that on behalf of the copyright owner and pays out. Sound Exchange also does something else, and we'll talk about that in a minute. But for purposes here, the recognition is that in order to do anything with this song, with the version of Hurt as recorded by Johnny Cash, you're going to need the mechanical rights and the performance rights, and you're going to get paid a statutory mechanical royalty if you're Trent Reznor for having written the song. You're going to get a performance royalty every time the song is played on the radio. You're going to get a performance royalty every time the song is played on digital radio. If you're American Records, you're going to get to negotiate a rate for what you're going to charge to purchase physical copies of your mechanical rights in the sound recording. You're not going to get anything when the song is played on the radio, and you're going to get a digital performance royalty as the owner of the composition, or so owner of the sound recording copyright, when the version is of Hurt by Johnny Cash is played on digital outlets. And again, digital is online streaming, satellite radio, Pandora, and Spotify. So both interactive and non-interactive streaming both pay a digital performance royalty for use of the sound recording copyright. Regular radio, regular TV do not. Okay, and again, here we see Harry Fox handles mechanical rights, ASCAP, BMI, and CSAC handles performance rights, and ASCAP, BMI, and CSAC handles performance rights for digital transmissions for the composition copyright holder, and Sound Exchange handles the distribution and collection of royalties for the master sound recording copyright holder for digital performance rights. Gets a little confusing. Once you actually start using it in practice, it becomes a little bit more clear, and especially because there's really no negotiation that goes on here. The Harry Fox rate, again set by statute, 9.5 cents, or the current digital mechanical streaming rate. ASCAP, BMI, CSAC set their blanket license rates for the performance of the composition copyright, and then Sound Exchange collects a statutory rate for the digital performance of the sound recording copyright. So again, while some of these concepts are a little confusing when you first start looking at them, the thing that makes it a little bit easier is that there's no negotiation over what's being paid generally, and it's just a matter of making sure that you secure the correct rights, and that you have the correct licensing, and that you make the payments that you're required to pay, depending upon who you are in the chain. Okay, and then finally, synchronization licensing, right? So that was the third of the revenue streams. Again, there's a synchronization license that is available for both the composition and the sound recording copyright holder. So how does synchronization licensing work? Essentially, I'm a music supervisor. I want to put Hurt in the trailer for the movie Logan. I need to go to Leaving Hope Music and secure a license to use the composition, and I need to go to American Records and I need to secure a license to use the sound recording. So I have to go to two parties and get two separate licenses and pay a fee for each of those licenses. They're called sides when we're discussing music synchronization. So I'm going, and what I want to do as the music supervisor for Logan is I want to say I want to pay equal amounts for each side. So if my budget is 50 grand, I'm going to pay 25 grand for the rights to the composition and 25 grand for the rights to the sound recording. The license that you actually secure for the composition is called a sync license, and the license that you secure for the sound recording is usually called a master use license, and they're also again called sides when doing the negotiation. Sometimes one side or the other might have a higher value. And so you might pay more for one side over the other. So, for instance, we talked about Satisfaction, right? So if I do a version of Satisfaction, I might get paid $5 for my sound recording rights to the physical version, the sound recording that I create of Satisfaction. So the music supervisor pays me $5, but they might have to pay Jagger Richards through their publishing companies $5 million for the composition copyright. So there's no rule that says that each side has to be equal. This is why sometimes you might hear a song that you recognize the composition, but maybe it's by an artist that you don't recognize their version, or a new artist. That's sometimes so that the music supervisor can pay a little bit less for one side over the other. Also, a huge trend in music over the last few years where we see a lot of independent releases where maybe the band owns both sides. The band self-recorded, so they own the sound recording, and they also have, as collectively as a band, or maybe one of the members wrote the compositions. So the band itself controls both sides. A music supervisor can go there and say, "Can I just get one license that covers both sets of rights?" Very simple, pay one fee, and then they get the song that they can put into their project. And so this is why a lot of independent music is being used in film and television projects and commercials, and quite a few bands have actually been broken from the use of their music in synchronization because it's much easier to be able to go to an independent band and secure both sides from one party than it is to go and negotiate independently with Leaving Hope and American Universal for a big major song like Hurt. So as independent, if you work with or you are an independent musician, the sync licensing can be a huge money making area. Now again, once you get paid your sync fee, that is just for the right to incorporate or reproduce your song in the audiovisual work. There's also going to be a performance royalty. that's going to be paid by statute through the blanket licenses, through your PRO, and through Sound Exchange. So every time Logan played in the movie theater, there was also a performance royalty payable to ASCAP, CSAC, or BMI on behalf of the songwriter, Leaving Hope Music, and Trent Reznor. And there was also, every time that the trailer streamed online, there would be that royalty payable to the composition, and there's also going to be a digital performance royalty for the owner of the sound recording, American Records, every time the trailer was streamed live. When the trailer plays in the movie theater, no performance royalty for the owner of the sound recording for American Records, just the performance royalty through ASCAP, CSAC, BMI, whoever Trent Reznor is signed up with, and Leaving Hope Music. So not only do you get your sync licensing, but you're also going to get money every time the trailer is performed, or if it's a movie, every time the movie is viewed, and then later when it's streamed or sold in a DVD, there's going to be, or performed anywhere, you're going to get a performance royalty as well. So there's a lot of money that comes from syncing your music, because it's not just the licensing fee, which can be substantial, but there's also going to be a performance royalty that streams from that later. Okay, so let's start looking this in a graphic form so we can kind of visualize how all of this works. So for the musical composition, we see Trent Reznor here, and the white lines are going to represent rights, and green is going to represent money. So Trent Reznor gives his rights to Leaving Hope Music. They don't have a logo I could find, so I just used a generic CD as the representation for Leaving Hope Music. So Trent Reznor assigns his rights to his music publisher, Leaving Hope Music, and let's just say he has a 50-50 revenue split. Of course, I'm not exactly sure what his revenue split is, but you see, for purposes of this illustration, Trent Reznor assigns his rights to his music publishing company, and then has a 50-50 revenue split on everything that they collect from use of his publishing rights in the composition copyright. Okay, then Leaving Hope has an agreement with Harry Fox, HFA, so Harry Fox will administer the mechanical rights. Okay, so again, what does that mean? That's this compulsory mechanical license that we talked about. So when American Records wants Johnny Cash to do Hurt, they go to HFA, they say, we're going to do a cover version of Hurt from Leaving Hope Music via Trent Reznor. We would like to seek a compulsory mechanical license, which is covered in 17 USC section 115, and we're going to pay 9.5 cents every time we sell a copy of that in a CD or on vinyl or an actual digital download. Perfect. Harry Fox handles that license. They handle collection of the money, and then they take their cut, and then they pay Leaving Hope Music. While we're going to use that assumption for the rest of this illustration, there is also a chance, and probably very likely, that instead of going through the compulsory mechanical license provision and HFA, the American may have negotiated directly with Leaving Hope Music, purely for administration purposes. When you secure a mechanical license through Harry Fox, you are required to do an accounting monthly on sales. Oftentimes, record labels do not want to count monthly. They would rather account twice a year or quarterly or maybe even once a year. And so they will go directly to the publisher, skipping Harry Fox, and they will negotiate a slightly higher mechanical royalty rate, so maybe 10 cents per copy, in exchange for the reduced obligation to only have to account twice a year or once a year. So that can happen, but don't get too focused on that for purposes of this illustration. We're going to say that that there was a mechanical license secured through the compulsory terms of the Harry Fox licensing under 17 USC 115, and that American is simply accounting monthly through Harry Fox for all of this digital, all sales, of physical copies of Hurt, and paying the 9.5 cents per copy sold. Okay. We also have the mechanical rights that are going to come from streaming. And as we talked at the beginning of the workshop, the law says that interactive streaming, Spotify, Apple, Pandora, and the others, where you get to choose what song you listen to and when you listen to it, the law says that is a mechanical right. It is essentially the same as owning a copy of the song, and so we're going to treat that as a mechanical right, and therefore there needs to be mechanical royalty paid. But obviously, we know that you can't pay 9.5 cents every time a song is streamed. That doesn't make sense. So there's actually a digital formula that was created that the music streaming companies have to pay. You may have heard of the Music Modernization Act that was recently passed and has started to take effect. Part of the Music Modernization Act was to create a three-judge panel that sets this statutory mechanical streaming royalty rate periodically. This is also, if you may have heard in the news about the lawsuit that was brought by all of the streaming services other than Apple. They all are trying to fight the recent increase in that mechanical royalty rate that was set by the judges and dictates what they have to pay to the songwriters for use of the composition copyright as a mechanical right every time a song is played through their digital streaming services. So, for mechanical purposes, if you're selling CDs and DVDs and the traditional distribution methods of selling a product, you're going to get a compulsory license from HFA and you're going to pay the statutory fee. If you're streaming, you're also going to go through HFA, and HFA is going to collect this digital streaming right and collect based on the royalties set under the Music Modernization Act by the three judge panel, and you're going to pay that royalty. It's going to go through HFA and then through to the publishing company and then to Trent Reznor. That part of it is going to change slightly again under the Music Modernization Act. They're going to create a new agency, not HFA, but a new agency that's going to handle just collection, licensing, and distribution of streaming mechanical royalties so that it streamlines the process so that if you are leaving Hope Music and you control the rights to Hurt, you will just simply sign up and say, we have a song, it's called Hurt, here's all of the information about the song, and then this new agency will then be able to contract with all of the different streaming services, offer that song to them, and collect that statutory streaming rate that is set by the panel. This should make things much more streamlined and easy. Right now, the problem is that if you don't sign up with Harry Fox and you're an independent musician, obviously all the major record labels are going to do it. But if you're an independent musician and you don't sign up with Harry Fox, there's a chance that your music's being played through the streaming services and you're not getting a royalty. Additionally, some of the streaming services aggregate the amount of money that they collect and pay one lump sum out to whoever's collecting as the distributor, and they put both the composition royalty and the sound recording royalty into one check and pay one party. And then somebody down the line has to try to figure out how to divide out the composition money from the sound recording money, and it's very confusing and creates a lot of headaches. That is all going to eventually go away when there's going to be one entity that will control licensing and collection of digital streaming royalties. But right now, it's a little bit funky. Harry Fox is doing some of it. Some people are negotiating independently if they're larger entities, and some people just simply aren't getting their money at all. And some people, the money is being aggregated along with their sound recording royalties into one lump sum, and they're trying to figure out how to divide out the musical composition money from the money that's being paid for use of the sound recording. Very can be very confusing. We're hoping that when the Music Modernization Act and this new royalty board are in place, that it will help simplify that process immensely, and it will make it easier for the streaming services to remain compliant. It will create more money going to the songwriters for use of their compositions, and it will make the process much simpler. Okay, so that's your mechanical side on the left. Obviously, the publisher has the right to negotiate sync licenses directly, so they would work directly with the music supervisor for Logan and negotiate their side. Okay, ASCAP, BMI, CSAC. So essentially what happens is the relationship between the PROs, the performing rights organizations, ASCAP, BMI, CSAC, and the music publisher and the artist is that ASCAP, BMI, CSAC take the money that they collect off those blanket licenses that are issued to TV stations and radio stations and venues, and they collect money on behalf of the song, and they pay half of it to the publisher and half of it to the songwriter directly. So if you are an independent artist that does not have a music publisher, you will get paid all of that money. But they're going to give you two separate checks, essentially. They're going to give you a check for your writer's share, and they're going to give you a check for your publisher's share. But in this instance, where we have a publishing company in place, what ASCAP, BMI, and CSAC do is when they collect the money from the blanket licenses that are issued, they're going to give half of that money directly to Trent Reznor, and they're going to give half the money to Trent Reznor's publishing company, in this case, Leaving Hope. This is why if you work with independent artists or if you work with producers or anybody that's involved in the creation process of music and writing music, they get really excited about their performing rights organization, and they focus heavily on that one of 6 revenue streams because that's the money that goes right to them without passing through any middlemen other than the PRO, but the PRO pays them directly. So it doesn't go through their publishing company, it doesn't go through anybody else and becomes subject to deduction. It simply goes from their PRO, collected from a TV station or a radio station under a blanket license, and paid directly to them. So a lot of musicians, especially people that write music, get really excited about their PRO rights and being able to collect their PRO money because they don't have to work for it. Well, they had to work for it by creating the work, of course, but they don't have to work for the administration because their PRO will do that for them. Again, if this was an independent musician, if Trent Reznor did not have a publishing company, ASCAP, CSAC, BMI would pay him all of the performance royalties that they collect directly. Also, the independent songwriter would be able to sign up with Harry Fox directly and also negotiate their sync licenses directly. So basically, you would just move the picture of Trent Reznor into the picture in the middle, and Trent could do all this negotiation himself. But it's a lot of work, so that's why most artists at some point in their career, when they are big enough, will sign on with a music publishing company to handle the administration of all of this. But they'll still get paid their performance royalties directly. So super important, and something that songwriters are very passionate about is their PRO rights. Okay, so we've covered how the musical composition is going to work here for Trent Reznor when his version of Hurt is recorded, either by him or anyone else. But in this case, of course, we're talking that it was recorded by Johnny Cash. So Johnny Cash has a recording agreement with American. That recording agreement says American owns the sound recordings, but that Johnny Cash is entitled to an economic interest in those sound recordings. So what he's receiving under that deal, I'm not sure. Sound recording deals can vary widely. It can be an 80-20 split, a 50. It just depends on the nature of the particular deal. With lots of music that's done today, where the artist maybe records everything independently, it may not even be a recording agreement. It may just be a distribution deal where the artist retains all of the rights and simply uses a record label as a means to distribute their album. So they don't actually, the record label doesn't actually own the rights to the album. They have a license to be able to distribute the album and collect royalties from that distribution for a certain amount of time. So they just become a cog in the wheel. But under the traditional system, the label actually owns the master, has all the rights to do whatever they want with it, provided they have the license to or the right to use the composition. And then they have an economic right to pay the artist whatever it says in the recording agreement. Okay, so working our way around, the record label retains the right to directly work with music supervisors on sync licensing. So they will negotiate that themselves. And then we see this dichotomy transferring over from the previous slide where Trent Reznor has assigned his rights to Leaving Hope. Leaving Hope has assigned the rights to Harry Fox. Harry Fox issues a mechanical license to American Records. So that is how American Records is able to secure the composition copyright necessary to couple with their sound recording copyright in order to distribute mechanical copies of the song. That's it right there. Again, we're using the assumption that there was a compulsory mechanical license secured. Again, there's a chance that American probably just negotiated directly with Leaving Hope so that they could do accounting on something other than a monthly basis. But this is generally how it works in terms of securing a license to do a cover song. Okay, so now American has the rights that they need to utilize the song and to be able to put copies out there into the public. What does that mean? That means we have traditional methodology of distribution. Vinyl leads the way right now. Still CD, and then still some digital download. Traditional methods of distribution are now available to American Records to distribute the work. Again, once they get paid, they're going to owe 9.5 cents to Trent Reznor for each copy sold. And then they retain the rest. So whatever they've negotiated or whatever they've set as their retail price for the song, that is what the record label retains and then splits with the artist for distribution of mechanical copies of the sound recording. Again, that's the one revenue stream that is heavily negotiated and negotiated by your record label, and that's why they get to keep as much money as they do all the marketing and promotion, and then they handle negotiating and getting the best revenue rate by setting the retail price and by negotiating with the streaming services, the DSPs, Spotify and the like, for the rates that are going to get paid for the use of the mechanical rights in the sound recording. Again, the mechanical rights in the composition, those are set by statute, and so there's no negotiation there. And so really where the negotiation comes is in the use and the money that's going to be paid for the mechanical rights in the sound recording. Okay, so we have the traditional distribution. We also have the streaming distribution. Again, that rate is going to be negotiated between the label, if it's big enough, and the individual DSPs. In some cases, if it's a smaller label, there will actually be an aggregator in between. Aggregators are companies like CD Baby or TuneCore and the like that basically they negotiated rates with the DSPs, and then anybody that owns rights to sound recordings can sign up with an aggregator to get their music onto those DSPs. Okay. Then we have Sound Exchange. Again, Sound Exchange is the organization that handles collection of royalties for the performance digitally of a sound recording. Again, remember, sound recordings don't get paid anything when they're performed on terrestrial radio or standard over-the-air broadcast television. No royalty gets paid for use of the sound recording, but if it's streamed online, satellite radio, any digital transmission of a sound recording is subject to a royalty that must be paid to Sound Exchange. Again, that royalty is set by statute, and it's a formula that the digital providers must pay. Sound Exchange tracks everything online digitally and then sends an invoice to the different streaming companies or digital performance companies. Again, we're talking about digital radio, satellite radio, and then anytime a song is incorporated into an audio-visual work and then performed over the internet, YouTube. So Sound Exchange is going to collect money, and Sound Exchange works a lot like a PRO in that some of the money is going to go to the sound recording owner, in this case American Records, and some of the money is going to go to other parties. Okay, taking a step back, take a little bit of a breath. Sound Exchange, let's say they collect through the statutory rate that's set, they collect $1 on behalf of the sound recording for Hurt. Okay, again, we're not talking about the composition that's owned by Trent Reznor. We're talking about the sound recording of Hurt as released by American Records, recorded by Johnny Cash. $1 comes into Sound Exchange, collected from the public performance of that sound recording digitally. Half that money is going to go to American Records as the copyright owner or the copyright holder of record. American Records signs up with Sound Exchange. They say, we own this sound recording of Hurt. Sound Exchange collects the money. They pay half of it to American Records. The other half is going to go to the featured and non-featured artist, and also to the producer and to the engineer that created the sound recording. So Johnny Cash is going to receive a portion of the Sound Exchange royalty collected from Hurt, as the featured artist on that song. The rest of the band that played with Johnny Cash is likely going to receive a portion of the royalty as the non-featured artist. And then under the MMA, there was a change made that says that producers and engineers also get a portion of that money. So a buck comes in, 50 cents goes to American, the other 50 cents is going to be divided between the featured artist, the non-featured artist, and the producer and engineer on the sound recording. This was a compromise that was made in an attempt when the Digital Millennium Copyright Act was enacted to try to say, hey, there's a lot of guys and gals who performed in the studio on tracks and signed an agreement that said you're going to play on this song and get paid 50 bucks, and then the song goes on to make tons and tons of money, and they literally got $50 for the recording session that they sat in on and played and never saw another dime from any royalty or anything that came through from the use because they don't own the copyright. Okay, so in order to try to remedy that, when they created Sound Exchange and this new digital royalty on use of the sound recording, they said, let's set aside half the money and pay the people that actually played on the song. So you don't need to be a copyright owner. You don't need to do to have ownership stake in anything. All you need to do is say that you played and now produced or engineered a song, and we're going to give you some of the royalty that's collected. Kind of a nice thing that was done, very fair, but something that a lot of musicians don't recognize or realize is out there. So something that I like to counsel people that I'm working with all the time and say, you know, you need to sign up and make sure you go to every song that you played on, even if it's not one of your songs. If you played on it, you might be entitled to some of the featured or non-featured artist money that's being collected through Sound Exchange. And this money does not belong to, you're not taking it out of anybody's pocket. It's collected for you. And so it's not like you're taking it away from American Records and you're going to, violate the agreement that you signed with them. This is money that's being set aside specifically for you as the featured artist or non-featured artist on a sound recording. So Sound Exchange, again, they collect money and they pay the copyright holder for the digital use of the sound recording, and then they also pay the featured, non-featured, and producers that featured, non-featured artists and producer and engineer that created that sound recording. So kind of a nice thing. Not necessarily a lot of money, but if a song becomes huge and is a big hit, and you were just a studio musician, you could collect some money. If you're a producer, there's some money for you. And if you're the artist that was on the song, there's going to be some money that goes directly to you and is not subject to any type of splits with your record label. It's going to come right to you. So a nice thing there. So that's generally how sound recordings work and how they're monetized, going all the way back. You've got the 2 sound recordings and then the 3 revenue streams for each of those sound recordings. Looking at it in another format or chart, we see for the sound recording copyright, the rights you've got the mechanical rights. The record label owns that and administers that. If you're an independent artist, you would own it and administrate that. It is a negotiated royalty. It's the retail price that you set for sales of your song. Now, sometimes the royalty, the retail price, you're not going to be able to negotiate. So, like if it's Apple's going to either distribute for 99 or $1.29, and then they're going to go down if there's sales. So Apple's going to work with you on setting that retail price. There used to be a lot of negotiation around retail when there was big music stores where people were buying Tower Records and all that. It's less now. But essentially, whatever you set as retail is going to dictate the money that's going to be able to be there to be split for between the artist and the record label on sales of physical copies of the song. The beneficiary of the mechanical rights is going to be the label and the artist by virtue of that recording contract. Again, if there's no label in place, it's just the artist, but the artist is likely still going to split that money with somebody who's sitting in place of the label. Just distribution company, a distributor would be in that place, or they're going to simply sign up with an aggregator like TuneCore CD Baby or something like that, in order to distribute the music and get it onto the DSPs and get it out there into the world. So even if you don't have a record label and you're a completely independent artist, you're still going to use some third party to help distribute your music. The key difference is a record label owns the sound recordings. If you're an independent artist, you're just going to license the rights to use the sound recordings that you will maintain ownership of through some other party for a period of time. So streaming mechanical rights, again, owned by the record label, administered by the record label, and here again you do negotiate the royalty, this time with the DSPs, with Spotify, Apple, and the like, Amazon and the like. So again, you do negotiate your rates with the DSPs, and depending upon who you are and what kind of leverage you have, you can get a better royalty rate and whatnot. And there's also been lots of controversy here because sometimes the record labels will own a portion of the DSP, so they're literally negotiating with themselves when they're setting what that rate is. And they can work that to their advantage so that the money will go to the portion of their business that will pay out the least to the artist. That you can read a lot about how that works and the controversy around that as more and more things are conglomerated, and you actually have a record label negotiating with itself on the distribution outlet. The beneficiary, again, is the label and the artist. Okay, so master use, this is your synchronization right for the sound recording. Again, the record label or the independent artist is going to own and administer that right. Yes, you always get to negotiate what your side is going to secure as a licensing fee on sync. And then that money is going to be split between the label and the artist by virtue of that recording agreement. The performance royalty for the record label is going to own the performance right, but again, there's no administration, negotiation, or royalty paid for standard performance royalties on a sound recording. Only the digital performance that we see in the next box, where you can, and it's collected and administered through Sound Exchange. The rate is not negotiated, is set by statute. And again, 50% is going to get paid to the label and the artist, label as the copyright owner, and then the artist by virtue of that recording agreement with the label. And then 50% is going to go to the performer and the producer, depending upon, and it's going to be split depending upon whether you're a featured or non-featured artist, producer, or engineer. So that's how digital performance for the sound recording works. Again, regular performance, terrestrial performance, there's none. And obviously, if the song's being played live by a band, there's no sound recording involved, so no royalty for performance by a live band of sound recordings. Okay, musical composition copyright. Again, there's a mechanical right. It's owned by the songwriter and their publisher, administered by the publisher through Harry Fox, HFA. No negotiation. It's set by statute, and the beneficiary, again, is the songwriter and the publisher. Streaming mechanical, same thing, except the administration currently goes through HFA, but soon will go through this new administration agency that's going to be created under the Music Modernization Act. So that will be how streaming mechanical royalties are administered in the future. Again, the rate is set by statute by that three-judge panel currently, and the beneficiary, again, is the songwriter and the publisher. Synchronization, again, ownership by songwriter and publisher. And notice the difference why we don't say ownership is the band or the artist and the record label, because like we said, the record label is going to have a work for hire provision that says that they own it. In terms of composition copyright, the songwriter is going to own the copyright, and they may assign a portion of it to a publisher, or it might just be an administration deal, but the songwriter is always going to maintain at least some of, if not all of, the copyright ownership of their compositions. Different than a band, which would give up all of its rights to the record label in the sound recording copyright. Okay, so synchronization again, the publisher is going to administer the rights. Yes, you do get to negotiate the licenses. Again, your side, you get to negotiate with the music supervisor or whoever it is that's licensing your work. And the beneficiary, again, is a songwriter and publisher. And then here you do have a regular terrestrial performance right. You also have the right to collect, and your PRO will collect when your song is played live. So if there's a cover band that's out there, the venue where the cover band is playing will take the set list from the cover band and turn it into the PROs, and you will get some money if the cover band has been playing your songs. So live, you actually, get there is some significant money. Or if you're a songwriter and you wrote a really popular song, but it was made popular by somebody else, another band, every time they play that live in concert, you're going to be entitled to some performance royalties. That band turns in their set list. That set list gets reported to the PRO, and you receive some of the blanket license money that the venue paid in order to be able to play that song for the live audience. And then digital performance again is the same as for standard performance when it comes to the composition copyright handled through ASCAP and BMI. Again, it's not negotiated. It's set by the PRO. And it's kind of standard across the board. If you go on to like ASCAP or CSAC or BMI's website, and you were you were going to set up a digital streaming service on a website, you can actually go and see what you would have to pay and what license, what blanket license you need to secure. So kind of everybody gets treated the same, which is why we say that there is no negotiation, because you really don't negotiate. Some places might, you might expect that like Clear Channel or one of the big media conglomerates might have a negotiation with the PROs that covers all of their radio stations. But again, in general, it's not being negotiated. It's kind of a set rate by the PROs. Okay, so there it is in another graphical form to kind of illustrate the rights and the royalties and the revenue that streams from these two music copyrights. Again, a mechanical right split in two and a performance right split in two, and the master use rights. So essentially three revenue streams for the sound recording and three revenue streams, the same three for the composition copyright. That's giving us the two copyrights and six revenue streams, the 2x6. So let's talk a little bit as we wrap it up here about music streaming. Everybody always wants to talk about, okay, what's the deal with music streaming and how does it work? Okay, so let's talk about a dollar. So a music streaming service receives a dollar for in a total royalty for use and streaming of the song "Hurt." How is that? How many streams does it take to get to the $1? It really depends on a number of factors, but it can be a substantial and surprisingly shocking number of streams that need to occur before a song generates $1 in income from Spotify, Apple Music, Amazon, the interactive streaming services. But once you get there and you've made $1, what happens to the buck? So 58 and a half cents of every buck that comes through Spotify and 58 cents of every buck that comes through Apple Music is going to go to the sound recording owner, so the record label. 29.38 cents and 28 and a half cents is going to stay with the DSP. So that's the DSP's cut right off the top. So you can see, a lot of them advertise. We pay out 70% of the money. They keep 30% of the money. So right off the top, your buck gets cut by 30% directly staying with the DSP. And then the publishing money, and this is it's really funny because this is where all the dispute happens is over this mechanical and performance money payable to the composition copyright. Okay. And it's the lowest amount. This is where the big argument over what the DSPs have to pay, and the big dispute where Apple's the only one that's not fighting it. It's all over this 6 cents here, 6.5 cents, 7 cents in mechanicals and performance royalties paid to the composition copyright. This other money, this 58 cents, probably, like I mentioned before, because of the fact that there's investment by the major record labels into the streaming services, and they're collecting money on both sides. They're not really fighting about that money because they're kind of all sharing it anyhow. But the one area where only the artists are really a beneficiary, and the artist being in this case the songwriter, that's where all the dispute is, and it's over just the 6.7 cents. So out of a buck, you can see 58 cents is going to go to the sound recording owner, the record label, which it will then have to split in some way with the recording artist, depending upon how their deal is, and depending on whether the artist had an advance or still owes recoupables on it. Whole different discussion. 30 cents roughly stays with the DSP, and then between 6 and 7 cents goes to the songwriters for their two royalty streams, their mechanical royalty stream and their performance royalty stream. Okay, so looking at it in the context of whether you're a major label artist, an independent artist, or a self-releasing artist, from that buck, remember, looking at the bottom in red, and now we're taking kind of the average here of all of the DSPs because they're all kind of slightly different, but averaging them together, roughly, 28.95 cents stays with the DSP, Spotify, Apple, or Amazon. Okay, so right off the top, your buck, whether you're an indie, a major, or self-releasing, 29 cents stays with the DSP. The rest of it goes to your uh, goes to the owner of the sound recording and to the songwriters for their composition copyright, and the owner of the sound recording for this master sound recording copyright. Okay, so if you're a major label, again, 58 and a quarter cents comes to the major label as the sound recording royalty for the mechanical rights in the sound recording. Of that, 9.3 cents is going to end up going to the artist or the band. So out of 58 cents, 9 cents goes to the artist or the band on a major label deal. 48, 49 cents stays with the label. That's on a traditional 80-20 split. And you're probably really not going to see the 9 cents because you probably got some type of an advance, which is still being recouped. And so the 9.3 cents is just going to go towards recoupment on your advance. So that's how little you get under a major label deal out of every buck that is earned from the streaming of your music online. 9.3 cents. Kind of shocking. But as we go through this chart and we see, what you'd get under indie deal or under a self-releasing deal, you can see that the thought here as an artist is that if you're under a major label deal, they're going to be putting enough marketing and promotion in that you're going to sell a lot more copies or stream a lot more copies of your song under the major label deal than you would under the indie or the self-releasing, and therefore, you're going to make more money overall. A million streams is worth, at 9.3 cents is worth more than 10 streams at 52.4 cents, which is what you would get if you self-released. So that's kind of the argument for being with a major label, is that it's going to mean that you have more streams of your song, even though you're getting paid less per stream. Okay, but essentially that's what happens. So that's what the band is going to get paid. So under our example with Johnny Cash, his estate now would roughly get 9 cents out of every dollar that's earned streaming from Hurt. Then Trent Reznor, as the owner of the composition copyright through Leaving Hope Music, would get 2.6 cents of the composition performance right, and then would get 4.8 cents of songwriting for the mechanicals, and then another 1.3 cents from the songwriting on the publishing side. Remember when we talked about how music publishing through the PRO, when ASCAP, CSAC, or BMI collects money, they take half of it and they pay it directly to the artist, and then they take the other half and pay it to the publishing company. So when you have a major label deal, what's going to happen is out of that 6.3 cents for the composition's performance, the PRO is going to collect 3.7 cents. They're going to take their cut and they're going to pay the other 2.6 cents to your publishing company. Okay, that's the one half. Then they're going to pay the other 2.66 cents and they're going to pay you directly as a songwriter. And they're going to take the other and they're going to pay your publishing company. Then if you move down to the next chart, you'll see under the publishing company, under performance, they are going to take half that money and then pay you the other half. So essentially, out of the money that's collected by ASCAP or CSAC or BMI, you're going to get 75% of it, and your publishing company is going to get 25% of that money. Okay. Again, half of it's going to get paid to you directly. The other half is going to go to your publishing company, and then they're going to take half of that and pay you the other half. That's how the PRO money works under a traditional major label deal where you sign a 50-50 split on the publisher's side of the performing rights money. Again, on your mechanical rights, 4.8 cents to the songwriter, assuming you have that 50-50 deal with the major label publisher. So at the end of the day, the songwriter is going to get uh, roughly 13 cents, and the band is going to get 9 cents. So as you can see, under a major label deal, being a songwriter is huge because you could actually get more money as a songwriter on streaming than you can from as being the sound recording owner, simply because the sound recording owner, or excuse me, by being the band, the label owns the sound recording, but by being the band, because you are simply going to get a small percentage subject to recoupment under your recording agreement. But if you're a songwriter, you're going to get your royalties paid to you, not subject to recoupment, and it's going to end up being, even more money because of the splits that you have in your recording agreement. So songwriting is huge, as you can see illustrated here, which is why, even though on the previous slide we said, we're only arguing over 6 cents, but when you get down to it, and after everybody's taken their cut, when it comes down to what's actually going out to the artists and the songwriters, that 6 cents ends up becoming pretty big amount of money. Okay, so again, if you're on the indie label side, you kind of have the same breakdown if you're on the songwriter side, because you're going to be signed with a publishing company that's going to be administering and taking cuts, probably at a slightly less rate when it comes to paying out on mechanicals and performance. So you're going to have a slightly better rate than you would with a major publishing company, but nonetheless, it's going to be subject to those same type of splits. You're going to get a little bit more money because you probably just have a distribution deal. So instead of a label owning the rights to your music, you probably are just going to distribute through a label and have a 50-50 deal where you each get half of the royalties that come through on the sound recording. But again, the indie label isn't necessarily in a position to do as much marketing and promotion for your music, so you're going to be streaming less, presumably. And then if you do it all yourself, you can see that you're going to, at the end of the day, collect 64 cents out of the dollar, which sounds pretty good, but it's really hard to market and promote your music and get enough people to listen to it. So there are people who can do that. I've worked with a number of different artists that are really, really good and live in the world of digital technology and social media, of attracting an audience independently and getting millions of streams on Spotify without any machine working for them, strictly through their own efforts. Very difficult to do, but if you can do it, it can be, you can earn a lot bigger piece of the pie. But that is a special skill into itself, and so oftentimes you need the other components, the record labels and the music publishers, to help you, and therefore you're splitting the money. Again, the presumption being that if you're only getting 18 cents split between the band and the songwriters of royalties, that it means that the machine behind you, the industry presence behind you, is helping market and promote you to get you a lot more streams than you would get if you were, releasing through an indie label or self-releasing. But again, it's a big discrepancy between being with a major label and distributing yourself over the piece of the pie, 18 cents to 64 cents. So if you can do it yourself and you have the means and mechanism, there's a lot more money for you to be earned by self-releasing. But again, it's not that easy. It's a tough road to hoe. It's also tough to get a major label deal. But essentially, that is the way that it is broken down out of every dollar that's earned. And of course, there's lots of nuances to all of the things that we've discussed today, including everything from the dichotomy between the different players and how they all are interrelated on the label and distribution side, to what it takes, what's good and bad about a recording agreement, what it takes to enter into a recording agreement, whether you want to do it through just distribution means, how well you are able to monetize what you do through your social media presence, and everything in between. So But as a general breakdown, again, this is a nice way to think about music copyright in that the takeaway being 2 copyrights, 6 revenue streams, 3 for each of the music copyrights, and um, yeah, that's where we're at. So hopefully your heads aren't spinning too much. I know it's a lot of information. Of course, if you have any questions, you can always reach out to me. My email is M-A-R-K, at arclg.com, ARC and then LG for Law Group. And I'm happy to try to assist with any questions that you might have. And again, on the slides, as we wrap this up, you will see some citations to some interesting articles and to the specific laws that we were discussing today, specifically 17 USC 101, which is the Copyright Act itself, and then some articles on some of the interesting issues that are coming up. And again, this stuff's always changing. So I say that I give the caveat that if you are listening to this at some point down the line, check in with the latest on the implementation of the Music Modernization Act and how that's going to change how digital, mechanical, streaming royalties on the composition copyright are collected and administered. And that is where I will leave you today. And I appreciate you hanging in there, and hopefully you learned a little something about music copyright.